Hi, folks. I'm Greg McLawsen, the Affidavit of Support lawyer. I've spent the past 10 years representing green card holders in federal litigation to enforce the USCIS Form I-864. One of the defenses that we see most often in these lawsuits, I don't want to say it comes up in every single case, but probably 75 to 80%. One of the most common defenses is for the I-864 sponsor to argue that he was defrauded into marrying my client, that the whole marriage was a sham, the person married him only for a green card, and for that reason, he has no liability under the Affidavit of Support, so he argues. Well, that's just totally baseless. Allegations of marital fraud are not a defense to liability under the Affidavit of Support, meaning that there is no set of facts at all that the sponsor could prove in court relating to marriage fraud that would get him off the hook from liability under the Affidavit of Support. Let's look at why that is. Go back to 1996 when Congress decided to create the Affidavit of Support. Why did they do that? Congress was doing two things at the time. They were revising U.S. immigration policy, and they were also re-examining who is entitled to public benefits, sometimes referred to as welfare, in the United States. One of the decisions that Congress took was to remove most immigrants from eligibility for public benefits. We're talking about lawful immigrants who have legal status in the United States. Under the legislation passed in 1996, most green card holders, legal residents, were disenrolled from public benefits programs for the first 5 years of residency. So even if you went through the process legally, got lawful status, you were still ineligible for most public benefit programs for the first 5 years of your residency. What Congress did simultaneously was put a new financial burden on the shoulders of visa petitioners. So it said, we are not going to make the American public responsible as a safety net for recent immigrants. Instead, the person who brought that foreign national into the United States has a new legal obligation to provide financial support to that recent immigrant. It's something that lawyers might call a strict liability rule, meaning that if you bring that person into the United States, you have a strict legal financial responsibility to support that person. So let's fast forward, we're now, many years later, and we have foreign nationals who are bringing lawsuits to enforce that legal responsibility imposed on the visa petitioner by the Affidavit of Support. Now, those petitioners are arguing, hey, I'm not responsible. Yeah, I signed the Affidavit of Support. Yes, I brought this person into the United States. But I am arguing to you, court, that this person never loved me and I was defrauded into bringing them to the United States and I shouldn't be responsible. Well, courts don't buy that because they look at the law that was codified by Congress relating to the Affidavit of Support. And under that law and its implementing regulations, there are only 5 events that end a sponsor's obligation under the Affidavit of Support. In short, the Affidavit of Support ends when the sponsored immigrant becomes a citizen, has 10 years of work history, is deported from the United States and loses their legal status, or if they get subject to deportation and go all the way back through the immigration process in front of an immigration judge, or finally, number 5, if they die. But those are the only events that federal law has codified that ends a sponsor's obligation under the Affidavit of Support. Courts, including the Seventh Circuit, the 11th Circuit, plenty of federal courts within the Ninth Circuit, have looked at that legal regime and said, there's nothing in there that lets a sponsor off the hook from liability if they decided in the 11th hour that the marriage underlying this process wasn't real. Put in economic terms, the sponsor is the party who assumed the risk. So if you think about it as between the sponsor and just some average American taxpayer, who had the opportunity to either assume the risk or not with respect to the legitimacy of a marriage, right? If it is a particular US petitioner who met somebody through an online dating service and decided to sign binding immigration paperwork for that individual to bring them to the United States, that's a risk the petitioner took. It was their decision to get into this. The average American taxpayer had no opportunity to decide if this seemed like a wise course of action. And so courts are going to say, look, sponsor, you took this risk. You signed the petition, you signed the affidavit of support, you brought that person into the United States, and you are on the hook because there is nothing in the statute and regulations that lets you go through that process and then get out of jail free because you decided 12 months down the line that things weren't as they appeared. Let me say, having done this for about a decade and having looked at hundreds of these cases, in every case that I've looked at where the sponsor has made these allegations of fraud, they're totally baloney. The person never has some smoking gun evidence that they were defrauded into marriage. What actually happens is that they've married somebody from abroad, the marriage didn't work out, because guess what? Lots of marriages don't. And it doesn't mean that this foreign national had some crazy strategic goal that they made up of immigrating to the United States just so that they could later sue this sponsor under the affidavit of support. That's crazy, because what we're talking about here is $1,400 per month. And nobody goes through some multi-year strategic duping of the sponsor just to be able to eke out a living on $1,400 per month. That's crazy to think. So what you actually have in these cases is a petitioner and a foreign national who went into this with good intentions, thought they had a legitimate relationship that was going to work out, and it just didn't. And that doesn't show fraud on anybody's behalf. But even if it did, even if you had smoking gun evidence of fraud, what federal courts have said is that is a risk, petitioner, that you assume in signing the affidavit of support. But the practical consequence of that legal proposition is not that you have a bunch of immigrants enforcing the affidavit of support in cases that were based on marriage fraud. That is not what's going on. The practical consequence of that legal holding is that it limits the scope of these federal cases. If marriage fraud was a defense to the affidavit of support, then in every single one of these cases, you would get extensive discovery. That's the formal exchange of information. You might very well get to a federal jury trial on the issue of, did she or didn't she love me? And did she or didn't she go through this process for a green card? Because allegations of fraud are just categorically immaterial in these cases, you can't go through an extensive litigation process and take up a federal court's time litigating the legitimacy of a marriage, because all of that under the federal statute is just irrelevant. So what you've done by establishing this proposition, marriage fraud is not a defense, is you've streamlined these cases. And instead of having a situation where federal courts have to get into the business, which they don't want to do, of being this quasi family law divorce tribunal. Instead, these cases come down to narrow legal issues. Did the sponsor sign the affidavit? Yes, he did. Did the foreign national acquire residency as a result? Yep, that's going to be really easy to prove. Having done that, the only remaining issue in these cases is what was the foreign national's income, because this is all based on whether it was beneath 125% of the federal poverty guideline. That is the closed universe of factual situations in these cases. And federal courts do not have to get into this collateral litigation about what the bona fides of the marriage was and who really loved who. It just is not at issue in these cases. So that is the current state of the law in federal courts. Marriage fraud is not a defense to liability under the Affidavit of Support. As a consequence, these are streamlined, focused cases as Congress intended, because again, this is a strict liability regime. If the affidavit sponsor signs the affidavit, the person becomes a resident, and then their income falls below the specified level. That means the sponsor is on the hook to provide financial support, and there are no excuses to not providing that support. If you have questions about the affidavit, feel free to jump into the comments. I'm happy to answer them. If you would like an individualized case assessment, we do free Zoom consultations all across the United States. Hope that's helpful, everybody, and have a good week.